motion hardly ever goes to trial. It's only about 1% of cases. But that means that everything that's done should be shaped to the idea of when and how do we settle this case. And what it really is a process of figuring out what the case is worth to both sides. And once you agree on what the case is worth, it settles at that point. And then there's a certain amount of what we call motions practice, which is filing briefs with the court about this or that, and trying to get the case dismissed or keeping out evidence. And you usually won't have to worry much about that side of it, but just be aware that that's a lot of what goes on. And the conversation there with your attorneys is what they're going to do, and partly what is the value of what they're going to do. Very high quality work is also very expensive. A conversation I tend to have is, okay, how important is this motion? Is this a motion where you want my work at the 90th percentile of my best work, and you can have that for X cost? If you want work that is absolutely my best work, it's going to be more like 4X, because getting to that higher level, it's 3, 4, 5. I did 9 drafts once on a brief. It was a very important brief. So there's that conversation. What is good enough for this brief? And sometimes it really is that important, and it needs to have 6 drafts, and you just need to suck it up and pay $60,000 for the brief. But that's hopefully a conversation that your attorney is having with you to try to manage the litigation cost. Learning the facts about your side of the case is the next step. You should let your attorney know if you have problem documents, because there's nothing worse for you than to have a problem document pop up much later at an inopportune time. And it can be really hard to get clients to actually tell you what they did wrong, and even worse, the really damaging email after they did it. But trust me, you're better off if you let your attorney know confidentially and in a privileged way, and then your attorney may likely have to produce that, but you can do the damage control on it. You should talk with your attorney about who should be interviewed and how that should be done, who should do it. It's a little more complicated than it seems. If your attorney does the interviewing, it can potentially turn your attorney into a witness, and you don't want that. Sometimes you'll use a private investigator, sometimes your attorney will go with the private investigator, sometimes people in your organization will do the interviewing at the attorney's direction and create a nice record. You'll want to preserve and gather the physical evidence, so don't throw away anything physical that's related to what happened. They will be allowed to come onto your property and look at things. You'll want to be careful to preserve your privileges. Talk to your attorney about all the different privileges. In addition to the ordinary business privileges, as a mission organization, you may have some religious First Amendment privileges. You may or may not have some clergy confidentiality privileges. You may or may not have some psychotherapy-related privileges. Your medical and psych records are subject to things like HIPAA. So you need to figure out all of the privileges that could apply. Those communications should be clearly marked. And you can't just randomly mark everything that an attorney has ever seen as attorney-client privileged, because the judge will throw that out. There has to be reasons for the privilege. But on the other hand, what you don't want to do is, say, pull in an organization, give them all your documents. It is now available for discovery forever and ever, even if some of it was attorney-client privileged, even if some of it was privileged under clergy confidentiality. There may have been other First Amendment privileges. Brent will tell you, you hand over the psychological records to some outside party, you've waived the privilege. It's gone, and you can't get it back. So you want to be very wise and careful about who you hand things over to, and whether things are going to be happening in your best interest. For instance, an investigation should be impartial. You should not be trying to slant it in a particular way. On the other hand, you should not be having that investigation performed by somebody who's essentially a victim's advocate. You've got to have some balance there, and if you don't have the balance, you can wind up in a lot of trouble.